selling the home of someone who's passed away. If you're dealing with an estate or the sale of a home when someone's passed away, there's a couple of things for you to remember. First of all, if the home is owned by not just the person who passed away, but someone else as a joint tenant, then you don't have to worry about very complicated procedures or anything. What you have to do is get an affidavit of surviving joint tenant. Once that's signed and sent down to land titles, the surviving joint tenant gets the whole property. It doesn't go into estates, there's no probate, it's just done automatically. Now, if the person is not on title as a joint tenant, so they're on as a tenant in common, or if a deceased person just owned the property on their own, then you're going to have to go through a probate process. The process involves you making an application or having a lawyer make the application for you to get a grant of probate, which allows for the property to be sold. Now, in terms of a real estate purchase contract, it's really important to remember that when you're getting probate done, you're not sure how long it's going to take. Right now, it can take 2, 3, or 4 months. Sometimes it takes longer. So what you have to do is make sure you word the contract in such a way that gives you, as a seller, the flexibility of when title will be transferred. The person could still move in, the person who's buying, but they may not be able to get the title into their name. It can involve financial consequence to them if their mortgage is only holding their rate for a short time. And so by putting into the contract in advance, you protect yourself as a seller from that loss. The other thing is, it protects you from them being able to back away from the deal because you haven't been able to fulfill your part of providing them with a title of transfer.